Hi, this is Professor McLaughlin with a brief lecture on Chapter 43, Employment Discrimination. So, just as a kind of a preamble, because we skipped a couple chapters, there is a lot of law that governs labor agreements, and labor agreements are between businesses and labor unions. Many labor unions exist in the United States, and they are mostly blue-collar jobs, teachers, certain kinds of car mechanics. The automotive industry has multiple unions, truckers, that kind of thing. Labor law is related, but a very distinct area of law from employment discrimination. Employment discrimination law focuses mostly on employment situations where there are at-will employees and not a contract that's governing the relationship. So labor law, contract, bargaining unit governs the relationship. Lots of federal laws regulate that relationship. Employment discrimination really has to do with all the other workers who can be fired at will or quit at will, move around in jobs, and what kind of laws protect them when an employer discriminates against them. Oops. Sorry. So the case hypotheticals at the beginning of these slides are really good. I ask you to take a look at them. Sexual harassment can be very tricky to prove, but what you need to focus on is this idea that the law shifts the burden back and forth, which doesn't happen a lot. So think back on the civil law case chapters that we covered and most of the civil law cases that are in your book. The plaintiff sues and has the burden to prove that malpractice occurred or there was a breach of contract. The defendant simply defends. Sorry, I'm skipping a little ahead. The defendant simply defends, but the defendant in a discrimination case simply has to say, I wasn't discriminating. I was, as best practices, or I had a reason for this policy that was non-discriminatory, and then the burden shifts back to the plaintiff. But we'll talk about that in a little bit. So big overview, you have federal employment laws, you have state employment laws. We're talking about employment laws in terms of protecting certain classes of individuals who are frequently discriminated against. I put in your Blackboard a link to the California Fair Employment and Housing website. California has a lot of protections for employees, protections against discrimination that are in addition to the federal employment laws. So the big law that kind of began it all is Title VII of the Civil Rights Act. This lists who the protected classes are that employers cannot discriminate against. You cannot discriminate based on race, color, religion, national origin, or gender. All distinct things. Please note that age is not on there. Separate law governs that. Sexual orientation is not on there. Separate state laws will govern that. And but for our purposes, I want you to understand that the protected class is that list under Title VII. So watch the video that I put in your Blackboard for week 14. That video is based on English law, but it's the same idea. It's there's intentional direct discrimination where a policy is really in place or an transaction activity happened that was based on intentional discrimination. That's disparate treatment, being treated differently based on race, color, gender, that kind of thing. But there's also a limitation on disparate impact. So discrimination that was unintentional, a policy or a practice that was adopted by the workplace that disproportionately affects a protected class. Gender, could be any number of things. But disparate impact is very different than disparate treatment. And disparate impact gets at that unintentional discrimination, forcing employers to really look at policies and review them so that the effect of those policies isn't disproportionate but equal and equitable. Next couple of slides, spelling out the beginning of the how to prove that disparate treatment discrimination case. And this is the beginning of the burden shifting, where first the plaintiff employee has to show in law what we say a prima facie case of discrimination. On its face, it's discriminatory. And then the defendant employer has to state what the non-discriminatory business reason is for that particular policy. After stating that, the burden shifts back to the plaintiff employee to say that that's mere pretext. And that's in air quotes because pretext is really a lie. They say that's the non-discriminatory business reason, but it's not. And all of this can be proven with testimony, emails, proof of discussions, hearsay, what people maybe have said before they were fired and are no longer able to testify, that kind of thing. So this is a slide, this slide 43-9 is just describing the burden shifting. It's an interesting part of law. As I said earlier, in civil law, the burden's on the plaintiff to prove the case, the defendant simply defends. But here the burden goes back and forth. It's pretty interesting. And I guess our question is that a good part of employment discrimination law? Does that make it more complex? And we think about some of these situations, proving racial bias or discrimination and sometimes even proving sexual harassment can be very complicated and difficult. So sexual harassment can be between genders or same gender. And really, it doesn't have to have sexual overtones. It can also be, that is to say, it doesn't have to be that the individual discriminating based on sex really wants to have sex with the other person. It could be that they're discriminating because of the other person's gender. We call that sexual harassment because it creates a hostile, intimidating workplace that's based on gender. So this slide really is just saying the traditional, I couldn't get the promotion unless I had sex with my boss, or that the person was very physical, with the understanding that if you didn't allow that physicality, that you would not be promoted or get the hours that you want. That's the traditional sexual harassment. But take a look at that case in your book that's about the same-sex. Let me see. I'll try. It's OnCal v. Sundowner Offshore Services. With same-sex discrimination between men. Okay, so blowing through this very, very quickly, there's so much more to that, but we need to just cover the highlights of all the laws that govern the various ways to discriminate. So, as I said kind of in my comments on the video that I put in your Blackboard, we do not allow discrimination based on pregnancy. That's illegal. But I want you to consider the strain and the stress that missing workers, or if it's a rough pregnancy, a worker during pregnancy that's frequently sick, a worker who cannot lift heavy boxes. This becomes a burden for the workplace as well. We don't allow discrimination. It's illegal, but we want to make sure we're not vilifying or looking at the employer as acting irrationally. Sometimes discrimination, and I don't excuse it, but it happens for a business reason, but it can't be illegal. So I kind of just want you to look at both sides. Now, there are defenses to claims under the Title VII. Why would you discriminate against a protected class? Well, the employer might say, I'm not discriminating. I need someone who can lift a lot of heavy boxes. I have to have a man for this job. Certain things, certain industries, men are more physically, the most men are more physically able to do certain jobs, and that's a bona fide occupational qualification. You're also allowed to defend against maybe a claim of discrimination by saying, I have a merit-based system of promotion, and that worker, while in a protected class, did not have the skills necessary to be promoted. And then some of the more obvious ones, seniority systems, those can be legitimate. But if you are discriminated, you can file a federal claim with the Equal Employment Opportunity Commission. It's a federal commission. They'll come in. You don't have to quit. You can file the claim and remain working. The cases where workers did that, it's very awkward, and the employer should not be able to retaliate against that worker, but frequently they do. The EEOC will try and solve the problem through conciliation. If that doesn't work, the EEOC issues the right to sue letter, and the worker is able to sue the employer, and that's bad for the employer because the EEOC found discriminatory practices. Can't discriminate against older workers, and this protection is for workers over the age of 40. This is a slide just showing the Prima Facie case for age discrimination. And then discriminate against people with disabilities is illegal under the ADA. The Americans with Disabilities Act provides that public places and workers need to accommodate people with physical impairments, mostly deaf, ramps for people in wheelchairs, that kind of thing. This does not cover people with intellectual disabilities. Your slides describe the requirements for bringing a successful claim under the ADA. And then finally, equal pay. Now, there's a lot of statistics to show that women are paid less for reasons other than discrimination. One of those reasons could be that women choose lower paying jobs, women are out having children, and so they don't reach seniority the same way men do. There is a wage gap, but what explains it? Can discrimination only explain that? Why do we not have more women in the C-suite, in the corporate executive suite? Why are there so few managing female law firm partners? It has been argued that that's not discriminatory, but based on other factors. And then any employer who functions internationally, a U.S. employer, is still governed by U.S. labor laws, U.S. employment discrimination law. U.S. employers cannot run sweatshops, have child labor, that kind of thing. So all the laws that apply at home will apply for a U.S. employer that's functioning abroad and employing citizens abroad. And I think that's the end. Thank you.